How fortunate are we to have Professor Lucien Durvan as our chair at this point in our history? He is absolutely amazing, dedicated, committed, and focused on the mission of this section. And even though he's not in the room, I'm going to ask you all to give him just a round of applause in gratitude for what he does. I'm Judge Bernice Donald of the Sixth Circuit Court of Appeals, and I am the nominal moderator of our keynote panel this morning on criminal justice reform and some focus on the issue of bail reform. I want to introduce our panel, and I'm not going to give them the introduction they deserve because we only have 75 minutes. I want to start with Chief Justice Jeff Bivins, who was appointed as a member of the Tennessee Supreme Court by Governor Haslam in July of 2014 and elected by the members of the court to the position of Chief Justice in 2016. He graduated from East Tennessee State University, undergrad, and Vanderbilt Law. Chief Justice Bivins has worked in corporate law firms, in the business world. He has worked in the public interest sector and in government service. He believes that lawyers should be active in bar associations, and he understands the need for the judiciary to work to promote the fair administration of justice. He also has some advice that he gives to students, and that is, don't burn bridges because you might want to one day go back. And I think that's good advice for any of us wherever we are. I'm going to introduce all of them, but I'm going to ask you to give Chief Justice Jeff Bivins a round of applause. I also have to just tell you as an aside, when I called him and asked him to support an implicit bias initiative in Tennessee for judges, lawyers, and prosecutors, without hesitation, he said yes. He sent out a letter encouraging everyone to attend and learn more about the cause of implicit bias. That's the kind of justice that Tennessee has. Next, let me introduce Chief Justice John Minton, Jr. from the Commonwealth of Kentucky. He was elected to the Supreme Court of Kentucky in July 2006 and elected to 4-year terms as chief in 2008, 2012, and 2016. In 2017, Chief Justice Minton completed a 1-year term as president of the Conference of Chief Justices and chairs the National Center for State Court Board. He chaired, the National Center for State Court Board of Directors. He was appointed to the State Justice Institute Board of Directors in 2016, and he currently serves as its chair. He is working to curb prison costs and increase public safety. He served in private practice and on the circuit court, and he's a graduate of the University of Kentucky. Our third panelist is Julie Warren. And Julie is a graduate of Marshall University and of Regent University School of Law. She attended Georgetown Law Center as a visiting student. While in law school, she clerked on the Senate Judiciary Committee. She served 4 years on the U.S. Department of Justice at the U.S. Department of Justice, in Washington, D.C. And after a few years in private practice as a civil defense litigator, she returned to public service and began her work in the office of the West Virginia Attorney General, where she primarily served as an appellate advocate for the state of West Virginia and as legislative counsel to the Attorney General. She's a prolific author. She's written a number of articles. Money Should Not Come Before Safety, Being Right on Bail, Pretrial Justice in Tennessee. She's just written and authored a number of policy papers, and we're incredibly delighted to have her here today. So I want you, if I didn't ask you to give Chief Justice Minton a round of applause, give him a round of applause. And now, please give Julie Warren a round of applause. Okay, we're going to try to allow, out of our 75 minutes, a considerable amount of time for questions from the audience. But first, I want to pose this to Chief Justice Bivins. If Appellate court judges are primarily responsible for calling balls and strikes, and we are a passive institution who deals with what comes to us. What's the role of the bench in criminal justice reform, and how has the court in Tennessee been responsible for legislative reform? And you can stand at the podium or you can sit, whatever you want to do.
I'll just sit if I may. I think we'll want to make this as informal as we can. Thank you for having me here today. I will apologize on the front end that I do have to cut out a little bit early from this panel today, in part, and I will tell you why, because our court is celebrating the 10th anniversary of the establishment of the Access to Justice Commission in the state of Tennessee. So it's something that I think fits well with what we're doing here today. But I do have to slide out about 9:45 to meet our obligation of holding a press conference and doing other activities up at the library today to celebrate that. That being said, let me address the question that Judge Donald has posed. And that question is with regard to appellate judges. I think also I'll bring into to that conversation our relationship with trial judges and the fact that oftentimes we as appellate judges are former trial judges. I spent about 7 years on the trial bench, so I saw it firsthand in what we do. So as a trial judge, I think you have an opportunity to affect those changes directly, and you're seeing individuals day in and day out that are affected by the criminal justice system as a part of the criminal justice system, and you see the need for the changes that are there. As an appellate judge, much of what we do, quite frankly, is to exercise a bully pulpit. And that is one of the main things, particularly as the Chief Justice, that I've tried to do over the last 2 years. My first speech as the Chief Justice was to the Knoxville Bar Association in September of 2016, shortly after I'd taken office. In that speech, I said then, it's time that we in Tennessee start talking about and moving forward on comprehensive criminal justice reform. And it is a process. And unfortunately, I wish I could say that we're as far along as our friends in Kentucky, but we want to get to where they are on a lot of what they've done. But I think we're well on our way. And the way we do that is going to a lot of what I think Mayor Briley talked about, and that's changing the culture. Changing the culture by talking about it, by going out and speaking. And how can appellate judges affect that change? By going out and speaking to communities. In the last 2.5 years, I put 90,000 miles on my car going from Mountain City to Memphis, talking about the criminal justice system, talking about the justice system generally, including access to justice. And that's the way we change this culture. And let me give you one example of how encouraged I am that, albeit slowly, we are seeing the change in that culture take place. A few months ago, I attended a symposium hosted by the University of Tennessee at Knoxville, in Knoxville, but it was a gathering of rural judges and rural law enforcement folks, in large part to deal with the opioid issue. It was bringing together those individuals with the U.S. Department of Agriculture, which surprisingly to me and I think to others, USDA has an incredible amount of resources that are helpful with regard to the opioid crisis. But that being aside, the point was you had everybody there. As a part of that symposium, they had everyone go around and introduce themselves and talk about what they did and their thoughts about where we are in our criminal justice system. Almost to a person, the law enforcement officers that were there, again from rural Tennessee, but there were a total of 5 states, but it was primarily Tennessee. To a person, those individuals started talking about how they used to be a lock 'em up attitude type. They used to think we had to put people away, but they've changed their mind. They've changed their approach, and they now realize that we cannot incarcerate our way out of addiction. We cannot incarcerate our way out of mental illness. And that, ladies and gentlemen, is how we change the system, is from the grassroots up. And it takes the organic changes from that to where we ultimately will have those changes. So to answer your question, Judge Donald, from the standpoint of an appellate judge, we have an obligation to reach out, to speak out when we see these issues. We have an obligation to work with the legislature, to work with the executive branch. I am very encouraged by the emphasis that the new Lee administration is putting on criminal justice reform. And I think we're going to see great strides in that area in the next couple, immediately to some extent, but in a large way over the next few years. Again, we're not as far along as these folks are. I appreciate and respect what they've done, but we are, I think, on the right track.
So, Justice Bivins, I'd like you to comment also on just a couple of the specific areas of reform that you're most proud of, and then I want to have you focus a little bit on if there are reforms related to the issue of bail, because I think we all know that in our prisons and jails around the country, there's an overrepresentation of poor people, people with mental illnesses, and as you said, drug dependency. People of color are also overrepresented. So many instances, we had a program last year where a federal judge came and talked about some of his work on why innocent people plead guilty. But what's going on in the area of bail reform? Because that traps a lot of people in the system who might otherwise exercise other options. Could you talk about that, please?
Sure. And again, with regard to bail reform, I think we're well behind our friends from Kentucky. They have been a true leader in the country on that reform. Julie and her organization have come in and working with Kentucky and Tennessee and are really moving us in the right direction, working with the legislature. But from a standpoint of the judiciary itself, what's happening at this point in time is we are truly trying to seed an organic movement to do that, and that being working with trial judges to establish pilot projects in various judicial districts across the state. I think we have now, we just had a judicial conference a little less than a month ago, and I asked then how many, and I think we've got 7 that are either up and running or close to being up and running, that are truly trying innovative ways of addressing that within the current structure of the law. Now, that's because, and let's face it, we all know that there is a very strong bail bond lobby in the state of Tennessee, to say the least, huh, Julie? And we see it every day. Tennessee is not ready to go the full-scale system that Kentucky has done, unfortunately. I think we will, as we change the culture, we will ultimately get there. So how do we address it otherwise? We do this by using these organic programs, getting people used to evidence-based decision-making, using risk assessment tools that they do, finding alternatives to incarceration and setting monetary bail. We have a crisis in Tennessee at the county level right now. And that, I think, is going to be our secret weapon in ultimately getting to the reforms that we need in this state. I grew up in Kingsport, Tennessee, up in the very northeast corner of the state, Sullivan County. I was having a conversation with a trial judge from up there at one of our recent conferences. Sullivan County Jail up there is certified to hold 610 inmates. Right now, they're running over 900. Guess how many of those are on pretrial? Over 50%. And guess how many of those are nonviolent pretrial? Of that total, 90% of the ones on pretrial are. That, ladies and gentlemen, is something we cannot tolerate. What it does, all that does, is it's not assuring that they show up for their trials. What it does is costing them their jobs. It's costing them their families. It's costing the child support that's there. It's putting children on TennCare. It is all those things that are happening out there that we have to continue to educate and let people know. So from what Tennessee's doing, we've got a long way to go, but I honestly think from the judicial side, we're on the right track. We're starting to have these pilot projects. They're starting to grow up, and we'll ultimately be able to get to where we have statewide reform of the entire monetary bail system. And
I want to go to Kentucky, but first I want to stay with Tennessee for just a moment, because there is an incredible bail lobby. We know that. But I think that from the judiciary standpoint, we have to acknowledge that the lobbyists don't set bail, the prosecutors don't set bail, the others don't. We judges do that. Is there anything going on with respect to the attitudes and the criteria that judges use in bail setting to address that problem that you just discussed.
It's just exactly what I talked about.
Okay.
These pilot projects are
Right,
are
the
doing
risk
that.
assessments and
I have talked about that at our last 3 judicial conferences, encouraging people to work with it. There are grants out there that can help you with the establishment of those risk assessment tools with the personnel that's necessary to run those organizations. It takes an investment on the front end, and sometimes the counties are reluctant to do that. But again, what we have to do is educate those, and I think we as judges can do that.
sure.
To show that if they'll put an investment on the front end in some more like a probationary type approach to pretrial release, that the returns on that are so much better than they do. But part of it is we have to educate our trial judges that they have a lot of discretion under current law to do some of the things that we need to have happen. True, we need some changes, but they have the ability to do that. But they've got to be willing to take the risks that they perceive to be there.
Sure. Chief Justice Minton, notwithstanding Kentucky's showing in the NCAA tournament, we have heard.
Now, be nice. The fact is, Tennessee beat them 2 out of 3 times this year. But we won't mention that.
We have heard that Kentucky is way out front on a lot of these reform issues, and so I'd like for you to share with us what's going on. What was that motivation, and how were you all able to do some of the things that you've done in the area of reform? So I just want to turn it over to you to talk about what's going on in Kentucky right now.
Well, Kentucky's in a unique position with regard to the bail.
Can the people in the back hear?
To the bail industry. Can you hear me? Back in 1976, Kentucky's legislature took the incredibly courageous step of legislatively eliminating the commercial bail bonding in Kentucky. And I like to say it was a real forward-looking, and it was, but it's got a great backstory that I won't take time to tell. But it's a game of politics that the person who pushed that bill was angry with his bail bonding group in Paducah, Kentucky, and so that was the backstory. The thing that happened though was the elimination of commercial. We became the first state in the country to legislatively, statutorily eliminate the bail bonding industry, and we've had a target on our back from those lobbyists ever since. They would come back in a minute if we could, if there's ever a crack in the door. So we constantly have to remain vigilant about that, because their efforts are huge and they got lots and lots of money to influence legislators. But because the bail bonding industry was eliminated, then there had to be something fashioned to take its place, and so the legislature established the Pretrial Services department that was then assigned to the courts. So the Kentucky Court of Justice in 1976 established a statewide pretrial services department. And the job of the pretrial services officers would be to meet with the arrestee and interview the arrestee and get certain information that would assist the trial judge then in establishing a pretrial release consideration, considering things like the criminal history, the nature of the offense, whether the person had a job, what community ties did he or she have, those kinds of things. And the encouragement from the legislation would be for the trial judge, the bail setting judge, to not really to set a money bail. That was the goal in 1976. To release on your own recognizance would be the first line of consideration, and if that, then the default would be ultimately for some sort of bail set with surety or some other mechanism. That was the goal. As Julie will tell you, we have fallen far short of that goal, because if you listen to Justice Bivins, he and I will have the same basic story, although we have two different states. Our states share a long border and a common culture in lots of ways. There are vast differences between our states, but one thing is clear. Years ago, Peter Drucker said that culture eats strategy for breakfast, lunch, and dinner. And that's absolutely true in this area of bail reform. We have the bare bones for a model system, and in lots of ways we have made tremendous progress. But it's not where we should be. This arc of history, Bernice, that you talk about is bending slowly, and it's a very, very slow. But we're talking about incremental changes when we're talking about trying to change a culture that has been in existence for so long that money for some reason has become in our history the medium the presumption of innocence falls far, gets really skewed and obscured in the pretrial bail setting arena that we're in today. So anyway, since our court, then in 1976, the court system was given responsibility for pretrial release, then we as the court to have a rulemaking authority that we can exercise by constitutional authority to establish rules around that process. So it's a combination of a statutory process and a rulemaking process, and then over against that, of course, remains the discretion of the trial court judge as she or he considers how to establish a pretrial release system. So to kind of answer the original question about how do I see my role in that, because I see my role as the fact that because we do have the authority that was given to us by the Constitution to establish court rules, then we've established court rules that provide for administrative release of a certain level of low-level offenders, misdemeanants who have a nonviolent, non-sexual charge, that we can release those administratively by court rule. So we've taken a lead in trying to establish court rules around some of those things, and also because of the fact that Kentucky is a little bit different from Tennessee in another way, in that we're a unified court system. My role as the Chief Justice is the administrative head of the Court of Justice, and I think that that gives me a responsibility to take a lead when I think that there are policy matters involving the courts that require leadership. Then it's our job to take that lead. And also, as Chief Justice Bivins mentioned, we do have a bit of a convening authority that we can bring the groups together. But I think that we need to recognize the role of the trial judge. Ultimately, we have a role. We have a role to play, and we are ultimately the bail setters. We need to educate the bench in a big way about the impact that initial bail setting decision has. We participated, we're still participating this year in what's called the 3 Days Count initiative to try to really emphasize in the minds of our judges who are setting bail the impact that 3 days in jail has on the individual. I mean, the job that, in 3 days you will have lost, 3 days in jail, you will have lost your job. All the family support falls away. All of those things that happen with just 3 days in jail. So.
If I might follow up on the point Justice Minton made about the unified system versus a non-unified system, and emphasize that is truly a major stumbling block in Tennessee to the reforms we're trying to do. What our court as a whole really has no control over the county of judges, such as the General Sessions judges, and as most folks from Tennessee know, and if those of you that aren't would not, General Sessions judges are oftentimes the ones that set the bonds and make those initial determinations as to who will be or what the terms of the bond are, or whether they will be released on some other way. So the inability to have a unified system is a stumbling block, but we can't. That's just something a hand we've been dealt. That's not going to change. So it's something we're trying to work around and continue our efforts to work with those judges as well as the courts of record.
Okay. Thank you, Justice Bivins. We have one more panelist, but Justice Bivins has to go in about 5 minutes, and so before he leaves, I want to know if anyone has a question for him that you want to direct to him before he has to go. And I've gotten permission from Ms. Warren to defer for that if you have a question for Justice Bivins. Anyone? Yes, Madam.
I'm wondering, you mentioned risk
Could you stand up? I think your voice will carry more.
You mentioned risk assessments, and I'm wondering how Tennessee is accounting for the bias within the risk assessment tools?
At this point, the risk assessment tools are being developed at the local level. We have some of the projects that have adopted the Kentucky model, others that have not. So as far as doing a full validation study statewide with that, we're not to that point. But we are certainly encouraging those courts that are beginning the pilot projects that's an important aspect of it that needs to be balanced. And they are working with the national groups, with Julie's groups, and with others to be attuned to that and to be sensitive to that. We're probably not where we need to be, but I think we are recognizing that and trying to move forward with it.
Thank you.
Ms. Warren, before I come to you, did you have anything on that point you wanted to make right now about the bias and the risk assessment tools?
I mean, I think that it's fair to say that not all risk assessment tools are created equally. I mean, there are a number of risk assessment tools out there that are sort of hidden behind a proprietary veil, so you don't necessarily know what the formulas are. But then there's some, like the one that Kentucky uses, the public safety assessment, that uses very basic formula. And the Arnold Foundation, that they're the ones that created it, they go back and revalidate it regularly to study, and they put RFPs out there for academia to study whether or not it would have a racially disparate impact. And studies have shown so far that that specific tool has not. But again, all tools aren't created equal. And I am very leery of any tool that would not let me know what the formula that they're using is. I think that's important to know.
Is there another question? Yes. Would you speak up? Yes, good morning.
You mentioned earlier that, quote unquote, we can't incarcerate our way out of mental illness. And I know that the CIT, or the Crisis Intervention Training Program, originated in Memphis. Can you tell us about any other innovative programs for people with mental disabilities that the state of Tennessee has?
Not necessarily at the state level, but you're actually going to hear about one this afternoon, I think, when Sheriff Hall of Nashville will be speaking. There is, and I don't profess to be an expert on here. General Funk can probably speak to this or much better than I. But he is setting up an entire wing of the new jail that will be nothing but mental health beds. And so there is a real effort to identify those. Sheriff Hall has been a true leader, and he's trying to influence other areas of the state as well that will do that. So I wish I could tell you that we have good statewide presence there, but again, it's that culture change that's starting to take place slowly. As we talked about, we're not there, but I think we are beginning to do that, and we are beginning to recognize that not only are the addiction issues there, but the mental health issues are so important that we're going to try to make that work. But I think that when you hear Sheriff Hall later today, that'll be a good example of the model that we need to follow.
Chief Justice Bivins, thank you for being with us this morning. I know you have to go. We respect your time and appreciate it. Thank you so much.
Thank you. Good to see you. Thank you all very much. I apologize for having to cut out, but I've enjoyed being with you. Thank you.
So now, Ms. Warren with Right on Crime. Ms. Warren, and you can speak from there or here, wherever you want to speak from, but what have you been seeing around the country in terms of reform issues and the issue of bail reform? And if you could tell us a little bit about Right on Crime, Okay.
Sure. So Right on Crime is a national project of the Texas Public Policy Foundation. And a lot of people who've been following criminal justice reform sort of know that Texas was one of the first states in 2007 to really undergo some truly comprehensive criminal justice reform, which people who don't follow criminal justice reform sort of take that. They're like, wait, Texas? We don't associate Texas with criminal justice reform. But in fact, they were up against a cliff that's similar to what I think we're seeing at the county level in Tennessee, where they were just severely overcrowded, such that they were facing a potential consent decree and a $2 billion fiscal note to build new jails. And Governor Perry was like, well, we're not building $2 billion worth of jails, because we'll build $2 billion worth of jails, and in 5 years we're going to build $2 billion more worth of jails, and that's how that's going to work. He actually vetoed criminal justice reform in 2005, but by 2007 he's like, let's explore this. So what they've done is that they've really bifurcated how they look at crime, nonviolent versus violent, and see if they can divert people and supervise people in the community. So they put $241 million into evidence-based programming, and since then they've actually closed 8 prisons. And their violent crime rate has gone down. Now they are in the process of undergoing some bail reform this session. Governor Abbott's made it a part of his 2019 legislative agenda. A statewide risk assessment is a part of that. But what they've seen at the county level is that they've not really seen that they've seen the population growth in their local jails. And a lot of it's pretrial detention, and a lot of in their rural communities, it's having even some of them, one of the most severe impacts in the rural parts of Texas. And really, we see the same thing in Tennessee. We see the same thing in Kentucky. The issue of pretrial detention and the population growth in our jails is something that has really taken hold nationwide. New Jersey in 2014 underwent some pretty comprehensive bail reform, limited cash bail. They created a risk assessment tool, developed a pretrial services division, and invested in electronic monitoring, any way that they could supervise people in the community rather than keeping them in jail. Since then, their pretrial detention population's gone down 22%. And their crime rate's gone down. And I think one of the things that I like to point out to people is that if you do criminal justice reform responsibly, you actually benefit your public safety if you do it responsibly. And you can drive down your prison populations, your jail population, and public safety actually benefits from that. In Tennessee, many of our county jails are at capacity. Putnam County's at 141% capacity, and you'll have a number of jails that you'll see the same kind of overpopulation. Over 50%, well, about roughly 50% of our jail population statewide are pretrial detainees. 17% are pretrial detention on a misdemeanor charge. And in some counties, that percentage is a lot higher, and that has grown every year. And our jail population in 2000 was 18,935. Now, 2018 numbers, it's 31,108. And the growth is solely in the pretrial detention numbers.
Are any of those pretrial facilities right now under Justice Department monitoring? I know Memphis was for a time, and they were holding primarily pretrial individuals.
Not that I know of.
Okay.
I mean, I'm not aware of any. General Funk might know a little bit more if that's been something that's happened. I know some of the bigger counties. Davidson has a risk assessment tool, a pretrial services division. And they've taken significant steps. Knox has done similar things. Shelby has as well. But in our rural and suburban counties, there is severe overcrowding, and it is solely regarding our pretrial detention numbers. That is what is driving our numbers in Tennessee. And you see the same in Kentucky, but not quite. I don't think it's quite as severe as what you're seeing in Tennessee.
Did you want to say something, Justice Minton, on that point?
No, I was going to agree that I mentioned that in we have the pretrial services division, and in in 2011, we participated. I was a part of the task force. You'll speak with Secretary Tilley this afternoon. John Tilley was then in the legislature and chaired a commission to try to address some of these issues around pretrial detention and overall skyrocketing prison costs in Kentucky and the skyrocketing prison population. And so we began, at that time, by legislation and with agreement of the courts, we established statutorily the requirement for a validated risk assessment tool to be used. And so we began in 2011 to use the validated risk assessment tool to assist the judges in setting, pretrial release conditions, and to try to begin addressing the pervasive use of money bail. We saw some initial success in the reduction in the number of people detained pretrial, but then we saw it increase. Now, I don't know what theory Julie has. I'd love to know what happened in about 2014. The pretrial detention numbers began to increase. We have since that time begun to see a decrease again, incrementally, in the number of individuals held in custody pretrial on money bail alone. And we're thinking that the judges are listening maybe to some of this national conversation that's going on about the problems that are created by using just straight up money bail. So, as we have, Justice Bivins was very kind in his assessment of Kentucky, and I appreciate that. We have worked hard to make a difference, but we're not making the kind of difference I'm sure Julie would say that we should be making in progress that I wish we were making in the area of pretrial release.
Julie, how?
Yeah, I mean, I think looking at the CJPAC, and I'm not sure what that acronym stands for. It's a task force that Governor Bevin put in place to study the criminal justice system in Kentucky. Their working group noticed in the last 5 years that the low-risk offender, or the low-risk defendants, the number of folks getting assessed bail went from 22% to 31%. I think that also looking at that, it's kind of isolated to certain parts of the state of Kentucky, and I think a lot of it might be result of just whether or not judges trust the risk assessment tool. Obviously, the risk assessment tool, in my view, is meant to inform a judge's decision, not tell them what to do. Right. I think discretion is important to preserve, but I think that you might have a lot of judges in certain parts of the state that just don't trust it. So if the assessment tool is telling them this person's low risk of failure to appear, low risk of reoffense while on supervision, they may feel like they know better, and maybe they do, but there's a lot more people being assessed low risk that are getting assessed bail as opposed to just release on recognizance or electronic monitoring or some other way to supervise them in the community. And I think a lot of it might be just the judges just may not trust the pretrial system that has been presented to them.
That's a fair observation of that.
So, Julie, does your organization get actively involved in recommendations, or are you primarily a data collection and assessment entity?
Both. I mean, we're a think tank, but I'm also a lobbyist. So I feel like I don't really see myself as much as a lobbyist. I try to be an educator, especially with regards to this issue, because I think that a lot of folks may not realize the pretrial population is what it is. And when I come in, and our Department of Corrections, the Tennessee Department of Corrections, every single month issues a jail summary report. And that they give you the data for the last 10 years on the average, how it's gone up. So, but I don't think a lot of people really look at it except me, because I'm a data nerd. So I look at it and I show people, I'm like, look, this is what cumulatively has happened in the state of Tennessee. And even some judges have been surprised because they know what's happening in their courtroom, but seeing the cumulative impact and see that, okay, all of the reliance on bail as the condition of release has given us a 50% population of pretrial detainees.
Right.
So.
Chief Justice Minton, we have talked a lot about Kentucky and Tennessee this morning, but your chair, either now or have been the chair of the Conference of Chief Justices, and I want to know what in the conference are there entities, states that you see there, or reforms that seem to be pretty much touted by or addressed by many of the states that are in common? If you understand the question.
We in the area of pretrial, of course, on the national scene, we all would look to the District of Columbia, which has had for the longest time a pretty robust pretrial services, and Julie's, I'm sure, very aware of the D.C. model, and we all were looking to D.C. to see what are they doing. Of course, one of the things they're doing is they're spending quite a bit of money on the services that are available to. I mean, that's the problem. You know, money gets to be the problem ultimately when you're talking about operating the court system at the state level. And I've got pretrial services under my broad umbrella, and I'd love to do more with what options does the trial judge have when the person's before the judge and needs to set bail and would like to be able to do something besides, you know, incarceration. Needs some supervision out in the community. So what supervision out in the community is available? Well, in D.C., they have had a very robust system of developing mechanisms, tools for the judges to use to allow to keep the person from being detained pretrial, some monitoring in the community of different types. So, you know, we look to D.C., we see what they're doing. That's one example. Of course, we have just completed a nationwide effort studying the effect of kind of following on the events in Ferguson, Missouri, for fines and fees and bail practices, and how that feeds a system that is unhealthy. And we've discovered there's quite a bit of work that needs to be done on the whole area across the country on fines, fees, and bail practices. We found in Missouri and in Texas and lots of places where there are local courts that, for example, in St. Louis area, you know, those little municipalities were funding themselves. The courts were the cash cow, the fines, the fees, that was paying for city services. And so if city services were lagging, the information from the mayor's office to the police department to the judges was, you know, we need to beef up a little bit. The policemen need a raise. Somebody needs a raise. Let's write more tickets. Let's generate more revenue. I mean, that's the impetus that was feeding this in lots of places. And so what's the role of the courts in trying to take control of, or trying to have an impact on that? So we've spent a lot of time studying that and trying to figure out how can we approach it. It's a big issue across the country.
Ms. Warren, did you have a comment on that?
Yeah, I mean, there are a lot of local jurisdictions that have sort of taken control of their own. I mean, I'm going to mention Nashville because they have the risk assessment tool and a pretrial services division. In Philadelphia, the prosecutor has just made it a policy of his office that certain offenses, they just weren't going to seek bail. They weren't going to ask for cash bail, and the judges have been very cooperative. They've really developed a relationship on that issue, and they've had successful numbers in terms of driving down their pretrial populations safely. And Atlanta has done something very similar, which I think they actually passed a city ordinance that eliminated the use of repealed any ability to use cash bail with regards to certain low-level offenses. That's relatively new, so I can't really tell you how it's. There's not much data to show how that's had an impact. Houston, the judges have gotten together with a cooperation with the prosecutors' offices to say we're not. In these situations, we're not going to use cash bail as a condition of release. So, I mean, it's been successful. Of course, they got sued by the bail industry. Harris County got sued by the bail bondsmen there on a number of. I won't go there, but yeah, I think there's been a lot of folks in public office, whether they hold a statewide office or not, or they've taken real control over this issue, and I think to the benefit of public safety and financially. I mean, because in Tennessee, for instance, just the pretrial misdemeanant population alone cost about, a very conservative estimation, about $206,000 a day just to house the pretrial misdemeanants. And that's conservative. It's probably about $350,000. So, I mean, it's these local communities are really, especially your rural communities like Putnam County, Sevier County, I mean, they are really getting hit hard with a big build, and probably are going to have to expand their jail capacities, which means, increase property taxes. So there's just this, it really hits every part of the community.
Okay, my final question, and that is, with respect to this whole issue of bail reform, have you noticed whether there is a difference in communities where judges are elected as opposed to appointed? I've seen some articles where people are talking about that issue, and I just want to ask each of you, does it make a difference? Does it make it easier, harder to promote these reforms if the judges in a particular community are elected as opposed to appointed? Julia, why don't I start with you?
I mean, I honestly haven't
What have you
noticed.
seen?
Honestly, I haven't really noticed that, because the judges in Harris County in Texas, they took the initiative themselves. They saw the issue and
they were elected.
Yeah.
Yes.
I think that the judges in Knox, Davidson, and Shelby have embraced some of this stuff. There have been a lot of interest in the pretrial risk assessment pilots by judges in Tennessee. So I don't really think I have the data to support that, what that fact that they're elected somehow creates more dependency on bail. I would get, and I think it's a fair thing to say, and I think if I were a judge, I'd feel the same way. You have, if you're a magistrate, you have 200 people in front of you that night. You really got to get it right, because if that person walks out of your courtroom and commits a violent crime, you're the one who let them out to do that. Giving them more tools so they can better understand who's in front of them. Otherwise, they sort of only thing they have is bail. So so they're using it, because at the end of the day, they are responsible if that person walks out of their courtroom and commits a violent crime. So I think that. And if you're elected, then you're going to be thinking about that in another way. So, I don't know, but I really think it's more about just having the tools to make a good faith assessment of that individual, more so than whether or not they're elected versus not elected.
Yes.
Well, I was going to say, I appreciate Julie's. I think she has a national perspective, which I don't have necessarily on that issue of elected. Because in Kentucky, we're all elected at every level. The Supreme Court justices, I'm elected on an 8-year term. Our trial court judges are all elected judges. So that's the only medium we have to work in, is the elected judges. And I also have been a trial court judge for 15 years. I was a bail setting judge, and I remember, the thought you have as the person is before you is the greatest fear that a judge, elected or non-elected, would be, that I follow the risk assessment. I release this low-risk offender into the community, and they commit another crime. And the headline is, Judge Minton set the bail, and this man went out and did whatever he or she did. That's what's going to happen. It's just going to happen. And so you got to be courageous in this job of judging. In those instances, that's one of the reasons it's a tough job. Mm-hmm. For elected and non-elected judges. You have, your name is the name that's on that order.
I certainly agree with that. And I think this harkens back to a point you made earlier about the need for education in the community, because people in the community don't always understand about the purpose of bail. They believe that, that bail is somehow to punish.
Yeah.
And a judge sets bail, and people, I cannot believe that on this heinous case, the judge only gave that person, a $1 million bond or whatever. So I think it is incumbent upon us to not only be courageous and do that job and to have as many tools as we possibly can to aid us in doing it, but also to help in the education of the public about the purposes of bail, because it's not to
Well, it's
punish.
true. I mean, I was reading this last week. The Courier Journal in Louisville had an article about one of the district judges, and that's our limited jurisdiction court where they do most of the bail setting. That's where the defendants and this judge ran on an idea that she was going to be serious about her role in dealing with the presumption of innocence, using the risk assessment tool, and being more proactive in allowing people to be released pre-trial. And she was being roundly criticized by the Louisville Metro Police Department for that, because they call it the catch and release program, from the law enforcement point of view. And so it's it's part of the pressure that the judge has would be from the prosecutor, who recommends bail and resists the defense effort to have it reduced. The pressures are huge on the judge, and I want to recognize that as I talk about the need to educate the bench. You're right, Judge Donald, the need to educate the public and try to help the public understand that there is a presumption of innocence. There is the idea of risk assessments that we look at. Those are tools. That's not the final answer, but the judge ultimately has to exercise discretion. We can't just commit them to jail, and the fiscal expense of that is huge. So all of those factors are part of this whole problem that involves educating the bench and the public.
Justice Bivins mentioned that 3-day, not 3-day rule, but that 3-day phenomenon, helping people understand what happens to the individual and the individual's family in that 3-day period. And so does Kentucky do something? I mean, do you all talk about it in that same context?
We do. We subscribe to the. We worked on the 3 days count initiative to try to educate the bench and the public on the impact that 3 days in jail has. It's somehow that magic number after 3. Or even with just 3, the impact is huge on the individual and the community. So.
Julie, you had a comment, and then I think I'm going to open it up to the audience. I just realized that we don't have to stop at 10:15. We go to 10:30. But
I was just going to say that Right on Crime joined the Justice Action Network and the ACLU of Tennessee to do some statewide polling, and I wish I had it in front of me because I can't remember numbers to save my life. But we asked people, registered voters, what they thought about bail reform, and once you kind of explain to them how bail works in the state of Tennessee, it was in the 70-something percent approved the idea of releasing low-level defendants. So, I mean, because I think there is more of an understanding that there isn't much of a payoff when you are incarcerating low-level offenders or low-risk defendants. I mean, there's just not the payoff. They're paying for it, and they're not really getting the public safety return. So I think that there is more, as far as the educating of the public, I think that a lot has been done in that area.
in Kentucky, Justice Minton, was there active support by the prosecution community for the reforms that Kentucky made? I mean, were your partners in that reform, or how did
Initially,
it go?
with the reforms, the more recent in 2011, there was it was kind of a joint effort, and the prosecution was involved in that. The more recent efforts legislatively to really, there was some pretty drastic legislation on money bail this last session, which just concluded, and it following the C.J. Pack report from the governor's office. So there's resistance from the prosecution in general, although not everywhere, because I would say just like in the larger cities, the Commonwealth's attorney in Jefferson County is a big supporter of the addressing the money bail issue, and there's a lot of leadership among the prosecutors in that area who recognize the very things that Julie was saying, that the public safety is not compromised, statistics show, whereas the physical impact is huge. So, it's kind of a funny thing nationally. This is an issue that gets support from the far right and the far left for different reasons. But it's an unusual thing that these two groups, these two ends of the political spectrum, come together on the need for bail reform.
Are there questions from the audience? Yes. And if you could stand up, please. Ian Main from Wisconsin.
Hi, Judge. Thank you.
Hi.
Is there a sense from the community when you go out and talk to people in the community that putting someone in a cage is a violent act? And if it is a violent act, which I think it is, that if someone's a nonviolent offender, why is it okay to put a nonviolent offender and use violence against that person in terms of punishment? And that's just one question I ask. Do they see it as an act of violence? Or do we look at people who are subject to the criminal law as somehow waiving the right not to do violent exercise against, like that we can't exercise violence against them? Is there any problem with that? And then the other question I have is more policy-based. In Wisconsin, in certain counties, we tend to throw a bunch of people into prison eventually or jail on bail jumping. The underlying cause, they may be innocent or not much, but it doesn't really matter. Once they didn't show up for court on time, the prosecutor was out of bail jumping. In Wisconsin, if it's an underlying felony, your bail jumping is going to be a felony, and that's it. Your leverage is gone as a defense attorney, certainly, in pushing back on that once you have the bail jumping charge. Are there communities who are reevaluating what the penalty is for, say, if you're going to put someone on electronic monitoring out in the society, and they violate the terms of that, but don't commit another underlying crime? It's just the violation of the terms of the electronic monitoring. Are there states who are not criminalizing that, but just again, returning them to pretrial detention? What are the options that say Wisconsin might have other than their current bail jumping statute kind of perspective?
Okay, I certainly heard part of that question directed to Julie, but anybody can start wherever they want to. Jump in where you fit in, okay?
I don't know about, the first part of the question about, I'm not aware of any, studies about the violent, caging. Is it caging violent?
Putting someone in prison is
Yeah, I don't know about
well,
that.
put me in cage, it's going to be a violent act.
Right. I gotcha.
I find that if you take someone and you put them in a cage, that is the definition of a violent act.
Okay. Yeah, I think we got the question. Justice
Yeah,
Minton
okay.
is just sort of musing as he.
Yeah. Well, here's the thing I was thinking about when you did talk about what we have learned in terms of this kind of addressing the party question that dealt with the bail jumping charges for missing court. We find that what we have are attendance problems as opposed to like rise in crime. People who get picked up because they didn't show up for court. And then they go to jail, and then they sit in jail at $300 whatever a day, or whatever the cost is. So we're looking at, as a court system, at least in Kentucky, at ways that, we're using text messaging now to, like you get for your dental appointment, to let you know that you've got a court date coming up. And we don't just tell you that, we tell your mama. Because we tell your mama that you've got a court date coming, you're going to show up for court. We're using those kinds of things to the extent we can. Again, it comes down to how can we, how can we use the limited resources we have to try to address some of those problems. And those court attendance problems that end up with people getting warrants for their arrest for failing to appear. If we can avoid those by doing a little more proactive work in certain ways, that's a good investment. That's a much better investment. So we're doing that. We're piloting those where we can afford them. We're doing it in Louisville. We're doing it around the country now. When a pretrial officer in Kentucky interviews the defendant, the arrestee, we take down information, including, now we want to send you text notifications. Give me your number. That's so we use it for that. And so we are generating these text messages to tell you to. That's just one of the things we've done to try to reduce the attendance problem that ends up being an incarceration problem. So.
And
It's
so
a small
Julie
matter.
responds, is there anything going on? I mean, you talked about the text messages. What about the other issues that that population will generally face? I mean, those, infrastructure, transportation kind of things. Are there pretrial officers that are also sort of helping to coordinate some of that stuff? And I don't mean that the court has to be totally responsible for the individual who's gotten themselves in that situation, but I just want to know what else.
Well, we
they
do
addressed?
have that in Louisville again, because it's for in my court system is the only really urban.
Yeah.
I'm a state of rural courts
Okay.
in Kentucky, but I do have one urban center, and that would be Louisville. And so we end up piloting a lot of our things in Louisville, and they are able to get grant money that can help us with more robust supervision from pretrial to make sure that you show up for court and make sure that some of these other things that you mentioned possibly that need to be done in order to stabilize the individual, can be done pretrial. So we're doing that. I wish I had more information about the project. That's it's a limited population right now, but we're trying it out, and if we can find resources to expand it, we certainly will.
Julie, if you could address that also, and could you also talk about whether there are any technological solutions that are also being advocated in that area? We have a system that's where people actually show up to a physical space to report, even if this is not a disposition date. Are there areas where people are able to go to a center and report in so that they and the court officer can make that appointment in cyber?
Yeah, I mean, Kentucky's kind of done some of that, but New Jersey has some of that. They, as a part of their reforms, they centralized a lot of their court system, which, as Chief Justice Bivins mentioned, would be super helpful. It makes it easier. I mean, it just logistically makes it easier. Also can, if something's not working, you can kind of point to it relatively quickly. But yeah, so they have these regional offices set up, and officers, pretrial services officers that are assigned to certain people that aren't released on their own recognizance. But to get to your point about nonviolent offenders, I mean, obviously, I would advocate that there are people who do belong in prison, but in terms of what the public feels about nonviolent offenders, I found our polling data. So the 90% of Tennesseans believe that we should reduce costly prison time for low-level nonviolent offenders. 83% think we're spending too much money on locking up nonviolent offenders. And then when we went down to the bail questions, 85% of voters, and this is, and these numbers were high, whether they were Republican or Democrat, approved of shifting from cash bail, particularly for low-level, low-risk offenders. So I think there is an appetite for changing the practice of incarcerating nonviolent offenders. And I mean, there's just been plenty of data to suggest that when you incarcerate a nonviolent offender, lock them up beside a violent offender, particularly for a significant period of time, there's a very good risk that they're going to come out a violent offender. So it can backfire on you tremendously. I also, if you have someone who's substance dependent or has a mental health issue, and that's really the trigger of their criminogenic behavior, I mean, warehousing them in Tennessee, the average sentence for a primary drug offense is 10.4 years. Warehousing them for 10.4 years, to what end? I mean, I think a lot of people are now asking themselves, to what end? What benefit do we get from doing that? I think there's a lot of really good programming in our Department of Corrections to deal with people who have these issues while they're there. But even our Commissioner Parker will say there's a lot of people in our facilities that should not be there.
Okay. April Frazier had a question, and then there was a question over here. April Frazier Kamara,
Hi. So I wanted
our
to
Vice Chair.
Thank you, Your Honor. I wanted to ask a question about cost savings because I'm from Tennessee, but I practiced in Washington, D.C., and D.C. does have the model pretrial system. But I agree, a lot of resources are spent on our pretrial services. cheaper to invest in pretrial services than sending money to the jail to incarcerate
true.
people. So I'm wondering, Judge Minton, has any studies been done in Kentucky about the cost savings, specifically to help states like Tennessee, who has very low revenue with no state income tax? How do you implement and show the cost savings in a state that does not have the revenue?
Yeah, that's a good question, because my job is in my role as the principal cheerleader for the court is always trying to convince legislators you need to spend your money here as opposed to there. I mean, I can't tell you how much of my energy is spent just trying to convince you, let's don't spend it here, but let's spend it over there. But it makes sense that we have a system of county jails around the Commonwealth. The counties operate county jails. That's the it's antiquated. It's ancient. It's an ancient it's a very inefficient process, but that is so deeply embedded. The principle of things being done, we inherited from our parent, the Commonwealth of Virginia, this county-centric mentality that we've been living into for a long, long time. And so to try to do a more effective way, the counties, though, are drowning, as Tennessee counties are too, in expense. The jailers, the county judge executives are constantly, their pressure is, let's reduce these costs. How can we reduce these costs? And one of the ways you can reduce these costs is to develop a more robust, for us, statewide pretrial detention mechanism that gives the judges and the communities a way to manage these people in the community with all kinds of resources. Electronic monitoring is one. Just simply not setting a cash bond in the first place is one, or recognizing that this person is a low risk. Don't put them in jail.
Right, and I wanted to do a follow-up question about how do you convince people to work themselves out of a job, and how do you train people to do something different? So if I work at the county jail in a rural area, and you're saying we're going to use electronic monitoring, has there been any thought given into how do you transition those workforces? Because the reality of it is we are talking about working people out of jobs.
Yeah.
And so how do we have these delicate conversations in rural areas where jobs are not there's not a lot of jobs.
Yeah.
So have you all had that conversation in Kentucky about retraining the workforce to do something other than locking people up?
I hate to tell you what really has happened. The few years ago, because the counties were having such a problem, the state agreed to house state prisoners in the county jail. So Kentucky and Louisiana, as far as I know, are the only two places where we put state prisoners in the county jail. That's a
They do it in
whole.
Tennessee.
They do it in Tennessee
Yes.
too? Well, I didn't know that. I'm sorry, but that's a whole nother hour and a half worth of discussion, Bernice, if we were to get into that, because it creates, people who are state prisoners doing time in county jails do hard time. It's a whole, the services that are available in the prison system aren't available in the county jails. If you offend some administrative regulation and you're in the penitentiary, you get an administrative sanction. But if you're in the county, you get indicted for having, contraband in the jail. It's a whole. So I'm sorry I even brought that up, but it's a complicated, many layers of history, and to try to address this thing on a statewide basis. Secretary Tilley will be here this afternoon. He'll have all the answers. You tell him I said so.
Okay. The gentleman behind you, and then I'll come to you, and that'll conclude our time. Yes.
Thank you, Your Honor. Excuse me. Where do you see the role of infrastructure, as far as the courts are concerned, in helping people make their court dates if they don't get a capias warrant? An example that I always saw, for example, I'm in Hillsborough County, I'll go to court, and people are always there with young children. We have a bad transportation system.
Yeah.
What have you seen, or where do you see the role of the judges in helping to provide for that infrastructure, or in providing understanding for people that need that infrastructure?
guess that's my question, huh?
I think that's
I thought so.
okay.
I suspected as much. Well, I mean, I see that. I think we're trying to address that. Again, it's a resource issue. I have some judges that would be oblivious to that. But let's just say that we've successfully. The judge recognizes that we've got a role to play here, and our role is we're seeing people who can't make it to court for what We've got to figure out some ways to work through that. And as I mentioned earlier, our text message thing to try to remind people about their court appearances. Now you're talking about just difficulties getting to court because they have like child care issues and elder care issues or transportation issues and those kinds of things. Those are all, hopefully we've selected people for the bench who have a really good judicial temperament who are able to work through some of those. But let's assume systemically, yes, those are all issues that we have a role to play. I mean, all I can say is we need to be a part of trying to help, form a solution. Do you have us?
I just-
You got an idea?
Well, we can get to these ideas, but I just want to say, too, I think we need to, as trial judges, when I was on the trial court, on the federal court, not on the state court, I must admit, but I think we also need to ask ourselves, when does the defendant need to be there? We, in the federal system, we set a number of report dates where the person comes and nothing is going to happen, but that person takes a day off work, and they might be before the bench sort of a nanosecond, long enough for the lawyer to say, Judge, we need another 30 days or whatever. So do we really need that defendant there on that day? And I think we, the lawyers and the judges and other people need to look at, are we requiring people to just jump through hurdles just because that's what we've already done it? Is there anything meaningful that's supposed to happen then? And that's a collaborative conversation that needs to happen between all of the constituents, and we need some retraining. But Justice Minton wanted to know whether you had suggestions.
In Orange County, Florida, they actually have a child care facility in the courthouse. And so people can bring their kids, drop them at the child care facility and, go to their court date. But to what Justice Donald said, in Hillsborough County, the judges will let attorneys waive their clients' court appearances for disposition days when they ask for a new court date. But for a long time, the public defender's office had some sort of policy of not letting the attorneys waive their client's appearance because they wanted to push the cases forward. But I think they're starting to rethink that because people with private attorneys, they're at the upper end of the economic scale.
Yeah.
It's impacting poor people more, and they were picking up on cases. So I think it's like we said, it's about education. It's about letting people know about disparate impacts.
Thanks.
Madam? And then I said last question, but we have to get Janet Fink.
Electronic monitoring has been mentioned a few times, so I'm wondering, a question and a comment, I'm wondering how reliant Kentucky and Tennessee are on electronic monitoring, and if the two states are using electronic monitoring to decrease the jail populations. Some people would say that electronic monitoring is not an alternative to incarceration, but it's the form of incarceration.
Yeah.
That's shifting costs onto the individuals that are being placed on electronic monitoring. There are user fees associated with it. Some people are paying $25 a day in some states. Illinois just the state spends $6.5 million for electronic monitoring. That does not include the costs that counties are spending on electronic monitoring for pretrial. So I'm wondering, the first part of the question is how you're using electronic monitoring. And then the second part is we are still spending a lot of money to incarcerate people, often in their homes.
Yeah.
There's a new term that surfaced, e-prison, so, but
Yeah.
Julie, go ahead.
Yeah, and I think that's a very fair point, that you are having that person incur some charges. In Tennessee, Governor Lee has a bill that is being very well received, and I believe, I'm very encouraged, I think it's going to pass, that he's going to invest a lot of money into the indigency fund, so people can tap into the indigency fund if they are placed on electronic monitoring. There was a bill, it's getting rolled until next year, that would specify that electronic monitoring is a condition for ROR. It already is, but right now, if you look at Section 116 that really kind of talks about conditions for release, bail is really sort of highlighted. We wanted to kind of highlight electronic monitoring. I understand. I get the argument that it is a condition, and it's not equivalent to ROR.
Right.
But if you're looking at someone who might lose their job, whose children could be put in foster care, we want to get them out. And if there is a concern that this person if the judge is just not confident this person is a low risk enough to ROR, I would like that as an alternative because right now the alternative is detention. And so I do believe it is superior to actually putting someone in a jail facility. So, so the indigency fund, I think, will help with a lot of that financial burden, because I think that we are recognizing that it is still a burden for someone to have to pay that.
I'm hoping we can continue some of that into the break, but I want to get Janet Fink's question, and then we're at the end.
Apologies for bringing up what may be to some slightly ancillary issue, but bail is often set for returns on warrants for violations, for example, of domestic violence, civil restraining orders or orders of protection, or child support orders or other orders on the civil side. My state just eliminated cash bail on the criminal side for all but violent offenses, but hasn't yet addressed these civil side bail issues. And I'm wondering whether Right on Crime or Kentucky or the Conference of Chief Justices have addressed that issue, and if there are best practices or particular states that have done it right in that context on the civil side.
On the civil
for
side,
bail.
I think that's going to be a part of the Texas. I looked at the Texas bill back in November. I know it's been amended a bit. I believe they addressed a lot of that in the Texas reforms as well as in the New Jersey reforms. I wish I could tell you what it all entailed, but if you look at those two states, they might be providing us best practices to come. So I wish I could remember exactly how they were addressing it, but I believe they were, and I believe New Jersey has. So maybe look at those states.
Please join me in thanking our panel, Chief Justice Minton, Ms. Warren, and Justice Bivins. Thank you so much.